Excellencies, dear colleagues and friends, ladies and gentlemen, all protocol observed, good afternoon. Heartfelt welcome to my fourth lecture, and many thanks for your loyalty in attending my four conferences throughout this month of November. This very last lecture is devoted to the public law of Africa and the self-realization of individuals and peoples. Last week, I have shown you that in addition to the process of challenging and adapting traditional international law to their needs and interests, the African states have gradually developed a set of specific legal norms to govern their mutual relations alone. In other words, a public law of Africa, which is an international law developed by African states for African states. I also indicated that this standard setting process was first set in motion within the framework of the Organization of African Unity. This is the flag. This was the flag of the OAU, Organization of African Unity, which was established in 1963. I showed that under the OAU, the public law of Africa was focusing on the state and its consolidation. Its essential purpose being state security. The only notable exceptions were the adoption of the African Charter on Human and People's Rights in 1981, the adoption of the African Charter on the Rights and Welfare of the Child in 1990, and the adoption of the protocol and the entry into force of the protocol, establishing an African Court on Human and People's Rights. The protocol was adopted in 1998. Today, we'll show that under the African Union, the current Pan-African organization, the public law of Africa has greatly evolved and built on the few achievements of the Organization of African Unity in order to promote the well-being of African peoples and their self-realization. This is the flag of the African Union. It's much smaller than, it looks much smaller than the flag of the OAU, but the organization has much greater political ambitions than the OAU. State security is no longer the main focus of the Pan-African organization. The public law of Africa is now aiming at, but not limited to, human security. Human security, that is freedom from fear and freedom from want, as proclaimed in the United Nations Millennium Declaration, which was adopted on 8th September 2000 by the General Assembly of the United Nations, meeting at the level of head of states and government. It is General Assembly Resolution 55/2. The African Union has notably provided the political and legal framework for the development and effective implementation of the African Charter on Human and People's Rights. Subsequent to the establishment of the African Union, the African Charter was indeed supplemented by 6 other protocols, namely, in chronological order, the Protocol on the Rights of Women in Africa, adopted on 1st July 2003, the Maputo Protocol, the Protocol on the Statute of the African Court of Justice and Human Rights, adopted on 1st July 2008, the protocol on amendments to the protocol on the Statute of the African Court of Justice and Human Rights, adopted on 27th, 2014. I will come back to these two statutes later on. Fourth, the protocol on the rights of older persons in Africa, adopted on 30th January 2016. Fifth, the protocol on the rights of persons with disabilities in Africa, adopted on 29th January 2018. And most recently, the sixth protocol is the protocol relating to the specific aspects of the right to a nationality and the eradication of statelessness in Africa, adopted on 18 February of this year, 2024. In addition to these six protocols, the African Union has adopted 6 other legal instruments, which, although they do not confer rights of their own to individuals, are intended to strengthen the protection of human rights on the continent. These 6 legal instruments are the protocol relating to the establishment of the Peace and Security Council of the African Union in 2002, the Convention on Preventing and Combating Corruption in 2003, the African Charter on Democracy, Governance and Election in 2007, the Convention for the Protection and Assistance of Internally Displaced Persons in Africa in 2009, the Statute on the Establishment of Legal Aid Fund for the African Union Human Rights Organs in 2016, and the Pan-African Investment Code in 2017, on which I had said a few words in the past weeks. The establishment of the Peace and Security Council of the African Union in 2002 is a particularly important development in the public law of Africa related to human rights protection. The Peace and Security Council of the African Union, composed of 15 members, just like the Security Council of the United Nations. This Peace and Security Council has been established notably with the objective, I quote, to promote and encourage democratic practices, good governance, and the rule of law, to protect human rights and fundamental freedoms, respect for the sanctity of human life, and international humanitarian law as parts of efforts to prevent conflicts, end of quote. The public law of Africa, designed to protect the rights and improve the well-being of the individuals in Africa, is therefore made up of no less than 15 legal instruments, in addition to the Constitutive Act of the African Union itself and the OAU Convention on Refugees, on which I dwelt on last week. That is, altogether 10 substantive instruments and 5 institution building instruments. 10 substantive instruments and 5 institution building instruments. Four major bodies have been created by these instruments to ensure the effective implementation of this specific branch of African public law designed to protect human rights on the continent, namely the African Commission on Human and People's Rights, the African Committee of Experts on the Rights and Welfare of the Child, the African Court on Human and People's Rights, and the Peace and Security Council of the African Union. These 15 legal instruments were the subject of the course I gave at the Hague Academy of International Law in July 2018. But the 5 one-hour lectures I devoted to these instruments were not enough to cover all of them. It will therefore be impossible for me to do justice to the great wealth of the public law of Africa in the remaining time allotted to me. That means that is in the 3/4 of an hour. This could be the subject matter of another series of conferences. Today, I will simply give you an overview of this specific branch of the public law of Africa, highlighting its most salient aspects, as well as any conceptual developments or innovative features. As at my 3 previous conferences, I have chosen 5 dates relating to 5 major events that I believe are the most relevant to my point. I will focus on the Constitutive Act of the African Union, the African Charter on Human and People's Rights, and 2 other conventions designed to protect children's rights and women's rights, the 2 largest categories of vulnerable people on the African continent. I will then turn to the African Court on Human and People's Rights, which mission is to monitor the effective implementation of human rights in the continent, but which I would say is on probation, since it could in the long run be replaced by another court with other expanded jurisdiction, the African Court of Justice, Human and People's Rights. I am starting with the African Union because its establishment in 2002 marked a paradigm shift in the life of the Pan-African Organization and in the content of the public law of Africa. This shift has been in favor of a greater consideration of the rights of individuals, the rule of law, and democracy in Africa. Since year 2002, ethical values have begun to take precedence over the cult of state sovereignty that was the main feature of the defunct Organization of African Unity. The creation of the African Union was decided on 9th September 1999, when the OAU Assembly of Head of States and Government met in Libya, where they adopted the Sirte Declaration, Déclaration de Sirte. In this declaration, the African Head of States stressed the need to revitalize the Pan-African Organization to enable it to meet the challenges of the 21st centuries, and therefore they decided to create a new organization, the African Union. The Constitutive Act of this new organization was thus adopted in 2000. It entered into force 1 year later in 2001, and the Pan-African Organization, the African Union, was finally launched in 2002 in Durban, South Africa. The Constitutive Act of the African Union marked a decisive turning point in the development of the public law of Africa, insofar as it gave this law a new impulse. I will limit myself to 3 salient features of the new organization. First, the operation of the African Union is governed by the principle of due respect for human rights. Last week, I indicated that the Charter of the Organization of African Unity did not consider the protection of human rights and fundamental freedoms as a matter of high priority. The Charter indeed referred expressly to human rights only twice, through a mention of the Universal Declaration of Human Rights in the preamble and in its Article 2. On the contrary, the Constitutive Act of the African Union places a strong emphasis on human rights. Indeed, according to its Article 3, two of the objectives of the Union are, I quote, to promote democratic principles and institutions, popular participation and good governance, and to promote and protect human and people's rights in accordance with the African Charter on Human and People's Rights and other relevant human rights instruments, end of quote. Article 4 of the Constitutive Act of the African Union, moreover, provides that the Union shall function in accordance with, inter alia, the principles of respect for democratic principles, human rights, the rule of law, and good governance, promotion of social justice to ensure balanced economic development, respect for the sanctity of human life, condemnation and rejection of impunity and political assassination, act of terrorism and subversive activities, and condemnation and rejection of unconstitutional changes of government, end of quote. The second major feature of the African Union is that its Constitutive Act recognizes a genuine right of humanitarian intervention in certain circumstances. Its Article 4H indeed provides for, I quote, the right of the Union to intervene in a member state pursuant to a decision of the Assembly in respect of grave circumstances, namely war crimes, genocide, and crimes against humanity. This provision has been supplemented by a protocol which is not yet into force. This right of intervention by the African Union in a member state is, of course, closely linked to the protection of human rights, as it can be seen as the counterpart of the concept of the responsibility to protect. Responsibility to protect, which was enshrined in the United Nations General Assembly resolution adopted at the World Summit in September 2005. The Constitutive Act of the African Union, I wish to underline that, is the only international treaty to expressly provide for such a right of intervention. The third salient feature of the African Union is that its Constitutive Act makes provision for a whole range of sanctions for state parties in the event of their failure to comply with the decisions and policies of the Union. I refer you to Article 23 and Article 30 of the Constitutive Act relating to sanctions and suspension. The African Union has actually imposed sanctions on several member states, primarily in response to unconstitutional changes of government, such as military coup. These sanctions include suspension from African Union activities and other punitive measures on individuals. The following 6 states have thus been sanctioned between 2019 and 2023, that is within 4 years, namely Sudan, Mali, Guinea, Burkina Faso, Niger, and Gabon. I would specify that the sanctions are decided by the Peace and Security Council of the African Union. The advent of the African Union also gave a new impulse to the development and implementation of the African Charter, to which I will turn now, notably with the operationalization of the African Court on Human and People's Rights, and the more prominent role given to the African Commission on Human and People's Rights. So the African Charter on Human and People's Rights, because of its general scope, the African Charter, as supplemented by its 7 protocols, is, so to speak, the hardcore of the public law of Africa in the field of human rights. The Charter is to Africa what the European Convention on Human Rights and the American Convention on Human Rights are to Europe and America, respectively. Last week, I have recalled the exceptional circumstances in which the African Charter was born and drafted. The drafting of the Charter was indeed an immediate reaction. It was prompted by the severe human rights violations that occurred in Africa in the mid-70s, in 3 African countries. I mentioned last week Central African Republic, Uganda, and Central African Republic. Forgot the other one. And I also mentioned that less than 30 days were needed to complete the drafting of this treaty, which consists in no less than 68 articles. The third country was Equatorial Guinea. Let me add that the African Charter was drafted in the midst of the heated debate on cultural relativism in governmental, academic, and NGO circles. The drafters of the African Charter therefore faced a major legal dilemma. That is, how to reconcile the legal efficiency of the treaty to be adopted, the requirement of the universality of human rights, and the distinctive features of the African continent at that time. What were these distinctive features of the African continent in the early 80s? First of all, the existence in the whole continent of a very strong feeling of community, the social structures giving indeed more importance to the group than to the individual. It's still the case today. Secondly, the economic underdevelopment of the African countries. It's still the case today. And thirdly, the existence of authoritarian political regimes, which were strongly sticking to the principle of national sovereignty and the one-party system. Things has evolved drastically concerning this third circumstance. The circumstances surrounding the genesis of the African Charter therefore explain, to some extent, its distinctive features, namely its conceptual originality, but also its very poor technical quality. I mentioned last week that the Charter was criticized, highly criticized, not only because it has included new concepts, but also because it was badly drafted. As I mentioned, one of the major criticisms was that the rights of the people might take precedence over the rights of the individual, notably insofar as the word people was not defined by the Charter. Another criticism was that the consecration of the duties of the individual aims at invalidating the individual's rights enshrined in the Charter. A further criticism was that the rights of the individuals were formulated in an imprecise manner and limited in a way dangerous to the individual. Indeed, the limitation clauses, the clawback clauses included in each rights were formulated in very vague manner compared to the way those clawback clauses, limitation clauses, are drafted in the covenant, the second covenant of the United Nations on Civil and Political Rights, and the two regional conventions, European and American Convention. In a nutshell, African head of states, were blamed for taking back with one hand what they gave with the other hand. I would add that the African Charter was also criticized because it only provided for a monitoring body, the African Commission, with very limited powers and not provided with a real independence. Let me make three main observations on this criticism without bothering you with technicalities. First of all, as soon as it was set up in 1987, the African Commission began to expand its powers and strengthen its independence through the adoption of its rules of procedures, which were amended many times since then. These rules of procedures notably opened the way for possible active role for NGOs, non-governmental organizations, in the work of the Commission. Hundreds of NGOs were thus granted observer status before the Commission. I say hundreds because I cannot keep track. More than 500 since the establishment of the Commission in 1987. More than 500 NGOs have been granted the status of observers before the Commission. These NGOs can propose items to be included in the agenda of the Commission, and they can also participate in the meetings of the Commission, in certain meetings, because certain meetings are in closed doors when it comes to examining communications. I mean, all the protective activities of the Commission are confidential, but the promotional ones are open. In the field of human rights protection, the Commission has enlarged its powers in order to deal not only with violation relevant to situations involving massive or serious human rights violations, as provided for by Article 58 of the Charter, but the Commission has also took the liberty to deal with individual violations. This is a major breakthrough in the activities and in the work of the African Commission. The Commission has also made full use of its prerogatives in the field of human rights promotion by regularly adopting declarations denouncing violations of the Charter by state parties. Although the African Charter is silent on the issue, the Commission has also created special mechanisms, special rapporteurs, working groups, and committees to examine issues of particular interest to its activities, along the lines of the special procedures of the Human Rights Council today. Human Rights Council of the United Nations. My second comment with regard to the African Charter is that although it was an imperfect legal instrument in technical terms, it proved to be perfectible, improvable instrument, thanks in particular to the work of the African Commission. The African Commission has indeed made full use of the principles of interpretation provided by Article 60 and 61 of the Charter. It has thus given the provision of the Charter the consistency they lacked in order to provide them with a similar content to those guaranteed by the two United Nations Covenant, for example, or the European and the American Conventions on Human Rights. Without wishing to minimize the importance of the work done by the drafters of the African Charter, and in particular of Judge Kebambai, who was the initiator and the main drafter of the Charter, I would compare the degree of completion of the individual rights enshrined in the Charter to that piece of rough wood. This is how I would compare the drafting and the content of the provisions of the Charter. Very well, very badly drafted. I would say that the African Commission has succeeded in carving this piece of rough wood and turning it into a beautiful statuette of ebony. Just like this one, which was fashioned by a very skillful craftsman in Tanzania. So this is how the rights look like now, compared to what they were in the African Charter. This is not ebony. I found that in the park of Villa Barton yesterday. The Commission has even created two rights from scratch. The right to food. It made a combination on the individual right to life, Article 4, and the right to health, Article 16, as well as the right of people to economic, social development. So altogether, the Commission used these three rights to build the right to food. The second right is the right of housing, the right to housing. The Commission did the same. The members of the Commission created a new right, the right of housing, on the basis of the combination of two rights provided by the Charter, namely the right to property and the right to health. Concerning the respect by the individual of its duties as set out in the African Charter, I told you that the Charter is devoting a full chapter on individual duties, 3 articles, but altogether 11 paragraphs. The African Commission has never made any pronouncement on this question. One can therefore respond to the critics of the African Charter on this point with a reference to the title of William Shakespeare's play, famous play, Much Ado About Nothing. It's equally important to indicate that the Commission has gradually given a broad interpretation of the concept of people. This concept, as I told you, is not defined by the Charter, but can be read in 3 different ways. As a people constituting the state, as the population of a state, or as colonized or oppressed people. This is expressly mentioned in the Charter. I would say that in the Charter, the concept of people therefore changes in content depending on the provision concerned. It is a sort of chameleon concept, chameleon-like concept, whose content depends on the function of the right concerned. It is actually the context in which the term is used that gives it its full meaning, a bit like the chameleon changes colors according to its environment. As from 2001, the Commission was bold enough to define the concept of people in a sense not expressly provided for in the Charter, considering that ethnic groups could be considered as peoples. However, in the few cases brought before it relating to the right of people to self-determination, the Commission has always refused to consider that ethnic groups had the right to external self-determination and could secede. This is to illustrate the way the borders were drafted. I said drafted by notably the Berlin Conference. You can compare the borders of Europe and the borders of Africa. The Commission's extreme caution is obviously explained by this arbitrary and geometrical drawing of African borders. And the African Commission has referred to this famous 1964 declaration on the intangibility, corrected to inviolability by my friend last week. As I mentioned, this declaration provides for the respect of borders inherited from colonization. An American author, Robert Lansing, in the early 80s, once compared this principle of self-determination to dynamite. I would say that, for my part, I would say that this the principle of self-determination in its external dimension, in the context of Africa, can be compared to a matchstick. It serves only once, namely in the sole context of the liberation of colonial peoples and those under racial domination in the southern part of Africa. I would finally observe that in its case law, the African Commission has made an implicit implementation of a particular provision of the fifth principle of Resolution 2625 of the General Assembly relating to the principle of international law concerning friendly relations. This provision, and this is an indirect reply to the question put by the lady 2 weeks ago, this provision indeed opens a very small window as far as the principle of external self-determination is concerned. It makes a very close connection between internal self-determination and external self-determination. The very last sentence of this subparagraph 5 is very important. And my reading of the case law of the African Commission led me to understand that the Commission, maybe without knowing, is endorsing this interpretation of the principle as enshrined in Resolution 2625. The very restrictive interpretation of the term people in the context of the right of peoples to self-determination, external self-determination, has not, however, been adopted by the Commission in relation to the other people's rights, that is, the rights of solidarity, to which I will now give my attention in my third and last observation in relation to the African Charter. It is indeed in the proclamation of solidarity rights, or third generation of human rights, that lies the great originality of the African Charter. These rights consist of the rights of peoples to development and equal enjoyment of the common heritage of mankind, the rights of peoples to peace and security, and the rights of peoples to a satisfactory environment. The inclusion of these three rights in the African Charter is a major innovation, as it is the first international treaty for the protection of human rights, and to my knowledge, the only treaty to date that proclaims these third generation rights and makes the peoples their exclusive beneficiaries. There are three other international legal instruments which have subsequently enshrined the right to development, but either as a right of the individual and a right of the people, or exclusively as a right of the individual. This includes the 1986 United Nations Declaration on the Right to Development, the 2004 Arab Charter on Human Rights, and the 2012 Human Rights Declaration of the ASEAN, Association of Southeast Asian Nations. By providing for the rights of people to solidarity, the African Charter tries to promote a new approach that is a global or structural approach to the question of human rights. It develops, in a way, Article 28 of the Universal Declaration of Human Rights, which provides, I quote, "Everyone is entitled to a social and international order in which the rights and freedoms set forth in this declaration can be fully realized," end of quote. For example, the right of people to development enshrined in the Charter is of particular importance in this regard. It should be understood mainly as a claim for the long-awaited new international economic order. It is a claim for more justice, more economic justice between the developed countries of the North and the countries of the South, the global South. As I said, it gives a political dimension to the Charter, this right to development. And it's meaningless because addressed to non-state parties to the Charter, it doesn't have any legal bearing. However, I will come back to the Charter, to the work of the Commission later. This right to development and the other rights, in particular the right to a satisfactory environment, give, as I just mentioned, a political dimension to the Charter, because they deal with solidarity. They deal with solidarity. And on this question of solidarity, let me briefly come back to the image of the chain that I used in my very first conference to illustrate slavery. In the field of development and environment, there's a need to strengthen the weak links of the chain, because the strength of the whole chain depends on the solidity of each of its links. One weak link, and the whole chain is weakened and can break anytime, whatever the solidity of the other link. This is one of the issues at stake at COP29, ending today in Baku, Azerbaijan, and which is closely related to the request of $1,000 billion minimum, in order to meet the needs of developing countries in tackling climate change. For African states, the right of people to development and enjoyment of the common heritage of mankind has become, in the economic sphere, what the right of people to self-determination was in the political sphere in the past, a vehicle for the liberation of African people. The inclusion of those rights in the African Charter must be seen in the light of the efforts made by the African states in the 60s and 70s to modify the legal regime governing the oceans and their natural resources, efforts which led to the inclusion of the concept of exclusive economic zone in the Convention on the Law of the Sea, the Montego Bay Convention, which was adopted in 1982, that is 1 year only after the African Charter on Human and People's Rights. The proclamation of the right of people to development in the African Charter does not have only a political dimension. The African Commission has indeed given a legal significance to this collective right. In some of its findings, the African Commission has thus indicated that ethnic groups within the state party to the Charter were entitled to the right to development as well as to a satisfactory environment. The Commission has also decided that these rights were violated by state parties concerned, by the state party concerned, and I would refer to the two most significant cases. The one refers to the Ogoni people in Nigeria, and the other one, the Andoros people in Kenya. I am coming now to the protection by the Public Law of Africa of two categories of vulnerable persons, namely children and women. I will start with children, whose World Day was celebrated 2 days ago, on the 20th of November. The African Charter on the Rights and Welfare of the Child is the regional counterpart of the United Nations Convention on the Rights of the Child of 20th November, which was adopted on the 20th November of 1989, that is 35 years ago, exactly 2 days ago, 35th anniversary. The African Charter is intended to fill certain gaps of the UN Convention, and as such has a remarkable added value to the UN instrument. In this respect, I will also make only 3 remarks. First, the major contribution of the African Charter on the Rights of the Child lies in its clear and precise definition of the child. The Charter indeed defines the child as, I quote, every human being below the age of 18. Below the age of 18. This is in very stark contrast to the ambiguous definition of the United Nations Convention on the right of the child, whose Article 1 states, I quote, "A child means every human being below the age of 18 years, unless the applicable law, the law applicable to the child of the state parties, provides for the majority attained earlier." So that means that the UN instrument provides for an exception. A child is a person under 18 years old, except if the municipal law of the state party concerned is providing for another age. In clear, under the African instrument, the child is defined by setting a floor age, 18 years old, from which there can be no derogation downwards. 18 years old, full stop. The second remark is that with this clear definition of the child, the African Charter provides a clear response to the problem of child soldiers in Africa. The African instrument formally prohibits the enlistment of persons under the age of 18, as well as their participation in armed conflicts. The UN instrument, for its parts, authorizes states, and African states in particular, to enlist children aged between 15 and 18 in their armies and to use them in armed conflicts. A slight progress has, however, been made with the adoption of the optional protocol to the convention, to the UN Convention, protocol on the involvement of children in armed conflict, adopted in 2000. My third remark is that the African Charter on the Rights of the Child formally prohibits the early marriage of children, stating that, I quote, "Child marriages and the promise of young girls and boys in marriage are prohibited, and effective measures are taken to specify that the minimum age for marriage is 18 years. End of quote. For its part, the United Nations Convention leaves the state parties a discretionary power in setting the minimum age required to enter into marriage. I'm now coming to the protection of the rights of women in Africa, which is provided by the Protocol on the Rights of Women in Africa. The Protocol on the Rights of Women in Africa is the very first treaty devoted to the general protection of women's rights, and is still the only one to date at both regional and universal levels. It has been adopted to complement the African Charter of 1981, as well as the convention, the UN Convention on the Prohibition of All Forms of Discrimination Against Women, adopted in 1979. This United Nations Convention has indeed a limited purpose. Its main aim is to eliminate gender-based discrimination and not, with rare exceptions, to confer special rights to women. Other conventions were also adopted at the regional level by the Organization of American States and the Council of Europe, but they also have a very specific scope, that is, granting civil and political rights to women, such as the two conventions adopted within the Organization of American States in 1948, granting civil and political rights to women, or the conventions adopted to prevent and combat violence against women adopted in the framework of the Organization of American States in 1994, the Belém-do Convention, and the Istanbul Convention of 2011, adopted within the framework of the Council of Europe. The African Protocol to the Charter on the Rights of Women can therefore be seen as a unique legal instrument of its kind with undeniable added legal value in comparison to the UN Convention and the other two regional conventions. Here again, I would simply like to make three remarks. First, the African instrument prohibits, I quote, all forms of violence against women, including unwanted or forced sexual intercourse, whether occurring in private or in public, end of quote. This prohibition is clearly aimed at non-consensual intercourse within marriage, which is equated to rape. The protocol is thus the first international treaty to address the issue of marital rape. Second remarks. The African Protocol is also more comprehensive than the UN Convention when it comes to women's control over their reproductive functions. Indeed, unlike the UN Convention, the protocol authorizes medical abortion in certain specific situations. Third, the African Protocol is much more specific than the UN Convention with regard to traditional practices likely to constitute discrimination against women. It indeed calls on state parties to, I quote, prohibit by means of legislative measures backed by penalties all forms of female genital mutilation, scarification, medicalization, and paramedicalization of female genital mutilation and all other harmful practices. End of quote. Let me now say a few words on the African Court on Human and People's Rights. The African Court on Human and People's Rights was created in 1998 by protocol, the Protocol of Ouagadougou, but was set up only in 2006 after some setbacks that time allotted to me does not allow me to describe. I had the privilege and pleasure to sit on the bench of the court during its first 10 years of existence. I must say that it was a passionate experience. There is therefore so much to be said about the court, but I will confine myself here again to 3 points. First, the African Court has a very broad substantive or material jurisdiction. It can indeed hear cases relating to violations not only of the African Charter and its protocols, but also, I quote, of any other relevant human rights instrument ratified by the state concerned, end of quote. Contrary to the African Commission, for example, the African Court is thus empowered to interpret and apply all the public law of Africa relating to human rights protections, as well as the human rights law produced by the regional economic communities in Africa and the United Nations. The African Court can thus hear any dispute concerning, for example, the application of the highly protective provisions of the 1996 United Nations Covenant, to which almost all the African states are parties to. It can also hear disputes concerning the application of certain treaties adopted within the RECs. I just mentioned the regional economic communities, such as ECOWAS, for example. And the African Court has not failed to do so and to apply those universal and regional instruments in some cases. By way of comparison, the material jurisdiction of the European Court in contentious matters extends only to questions concerning the interpretation and application of the sole European Convention and its protocols. The jurisdiction of the Inter-American Court, originally limited to the interpretation and application of the American Convention, has now been extended to 6 other inter-American legal instruments. Second remark on the African Court: the Court has a narrow personal jurisdiction. The Court is open to states party to the protocol, to the African Commission on Human and People's Rights, which is based in Gambia, Banjul, Gambia, but only on an optional basis, the Court is open to individuals and non-governmental organizations, only on an optional basis. So far, only 34 African states are parties to the protocol establishing the Court, out of 54 state parties to the Charter. All African countries are parties to the Charter except Morocco. Out of the 34 countries which are parties to the protocol, only 8 of them have filed the optional declaration authorizing individuals and NGOs to bring a case before the Court. Only 8. Burkina Faso, Mali, Malawi, Ghana, Tunisia, Gambia, Niger, and Guinea-Bissau. There were 4 other states that filed this optional declaration, but they withdrew their declaration from 2016 up to now. Those states were Rwanda. The first state to withdraw was Rwanda. The second was Tanzania, then Benin and Côte d'Ivoire. With this very weak number of declarations, the Court has jurisdiction on a very limited portion of the population of the African continent. The African Commission is also entitled to bring cases before the Court. It has done so in 3 occasions. The Commission brought 2 cases before the Court dealing with violations of human rights by Libya, and the Commission did the same with alleged violations by Kenya, on 3 occasions only, which is very few, which is not enough, I would say. I would say that the personal jurisdiction of the African Court in contentious matters is thus halfway between the jurisdiction of the Inter-American Court of Human Rights, which is open only to states, and the Inter-American Commission. The Inter-American Court is not open to individuals. The individuals have a standing, but only for the issue of reparation. But this is not very important as far as the full access to the court by individuals are concerned or NGOs. So the Inter-American Court has a very strict jurisdiction as far as who can file a case before it. So I said that the jurisdiction of the court, as far as personal jurisdiction is concerned, is midway, halfway between the Inter-American Court and the European Court, which, as you know, is open to states and individuals without any kind of conditions. My third and last comment about the African Court is that it is a judicial body on probation. In the past, I used the expression stillborn judicial body, or a body with no future. There are indeed plans to transform the current African Court into an African Court of Justice, Human and People's Rights, the creation of which is provided for by two protocols that I mentioned before: the Sharm el-Sheikh Protocol, which was adopted in 2008, and the Malabo Protocol, which was adopted in 2014. When those two protocols come into force, the new court will be a judicial body with an extra large jurisdiction. To summarize and to make a comparison, I would say that the new court, when established, if it is established, will have more or less the jurisdiction of five judicial bodies combined. It will have the jurisdiction of the current court, of African Court of Human and People's Rights, dealing with human rights. It will have the jurisdiction of the International Court of Justice, dealing with issues of general character, legal issues of general character. It will also have the jurisdiction of the Court of Justice of the European Union. That means the future court, the future African Court, will be dealing with the internal law and regulation of the African Union. The current court, the future court, will also have the jurisdiction of the International Criminal Court. And lastly, fifth kind of jurisdiction, the court to come will also have the jurisdiction of the dispute tribunal established within the framework of the United Nations to deal with issues relating to staff issues. I would say that the current court is a transitional body on the way to establishing a new kind of judicial body. I don't know if it will see the light, because this entails lots of financial resources and human resources, and I don't know if the African Union will have these resources in order to operate such a hypertrophied court. As I just mentioned, and I will be very quick now, I think it's important, this new court will have a criminal jurisdiction. This is the result of the growing frustration of African states with the International Criminal Court and universal jurisdiction. African states have therefore started looking for regional alternatives to deal with international and transnational criminality. The Malabo Protocol, when it becomes in force, will create a criminal chamber within the future Court of Justice and Human Rights. And under the protocol, this chamber would have jurisdiction over the internationally recognized crimes. That means war crimes, crimes against humanity, crimes against peace, and genocide, as well as 10 other grounds, 10 other crimes, namely human trafficking in drugs, human trafficking, trafficking in hazardous waste, mercenarism, piracy, terrorism, corruption, money laundering, illicit exploitation of natural resources, and the crime of unconstitutional change of government. It also has some provisions on individual criminal responsibility, corporate criminal liability, and also complementary jurisdiction with both national and regional court. but not one single word about the ICC, the International Criminal Court. The other original feature, but I would say unfortunate feature, of the Malabo Protocol is that, unlike the Rome Statute, it provides for immunities for high-ranking public officials in office, such as head of states and government, which is not the case within the International Criminal Court, as you know. And what happened yesterday is a clear illustration of this point of lack immunity of head of states before the ICC. I will now conclude very quickly. In my series of 4 conferences, I have examined the process that has led African countries and individuals to emerge from obscurity and subjugation and to gradually enter the light of economic and social development. I have tried to show how international law has first maintained African peoples in the bonds of slavery and colonialism, and has then gradually evolved to liberate them. I have also tried to show how the newly independent African states have developed their own legal rules, that is to say, the public law of Africa, in order to strengthen their sovereignty and statehood, and how, in a second stage, African states have produced legal norms aimed at securing the well-being of their people. Although these are essentially normative developments, which have yet to become part of the day-to-day practice of African states and of the organization, these developments nevertheless reflect a radical shift in the attitude and language of these African states over the last 60 years. The public law of Africa, as it stands, definitely provides the legal tools by which the African Union can implement Agenda 2063, adopted by the Assembly of Head of States of the African Union in January 2015. The vision of the African Head of States is that by 2063, I quote, African people will have a high standard of living and quality of life and well-being, meaning notably that Africans will be well-nourished, healthy, well-educated, with long lifespans. There are still some dark clouds here and there on the African continent, such as internal conflicts, hunger, and diseases. But it can undoubtedly be said that over the last 200 years, international law has helped African peoples and individuals to move towards a brighter world. Thank you very much for your patient attention. I went a little bit beyond. Yeah?
Some questions?
Of course, yes.
Must be a mic over there.
Thank you so much for this very interesting talk. One of the things that was mentioned in the previous slide, the crime of I don't remember exactly what it's called, but unconstitutional change in government. Yeah. How does that gel with the immunities that you then talked about? Maybe can you talk about that crime more broadly?
Wait. What do you mean by immunities? Immunities.
You said that there was that there's immunities for heads of state and of government, but
yes.
Wouldn't the crime of unconstitutional change in government, wouldn't that be sort of really only probably applicable to heads of government?
Yes, exactly, for states, constituted states. for the authors of coup. You are mentioning now the authors of coup. There will be a responsibility. Of course, they won't be covered by this immunity. They are just soldiers, whatever their grade. But they are not part of an official structure of the government. Because if you see how the provision is drafted, it's drafted in a very imprecise way, you know. This provision speaks about senior state officials. What is a senior state official? What is a senior state? Is a captain a senior state official? So this is very ambiguous. But this talks about the official structure of a state. But of course, if this ambiguity is also contained in other conventions. It's also contained, for example, in the Convention on Displaced Persons, which is also providing for certain crimes, which can be committed by international multinational corporations. So bringing the heads of those international corporations to justice in African states.
Does that mean that it would also be like, what about if a head of state were to try to remain in office beyond their constitutional mandates? How would that then fall?
See, those are theoretical pronouncements, you know. But in the reality, you know, as I usually say, the African normative system is very advanced. Everything has been provided by convention. The problem is the implementation. When it comes to unconstitutional change of government, the African Union has adopted many resolutions, in particular in Algiers, and has also adopted a convention, the African Charter on Democracy and Governance, in which the African states forbid a state to change the constitution before an election in order to allow a head of states to stay in power. But this has never been implemented. The only examples where the African Union is using sanctions is for military coup. This is the only occurrences, with one or two exceptions, as far as Gabon is concerned.
Yeah, thank you, Judge Ugarguz. I just have a question, perhaps about the next step of the jurisdictional function of the court. So, is there any body within the African human rights system responsible for the supervision of execution of judgments, like the Committee of Ministers and the Council of Europe? I know this is also a big issue in the Inter-American Court of Human Rights, where there is no such organ. So we saw these normative developments, but I'm wondering whether, to what extent can they be translated into practice in the region?
Of course, there is the mechanism. This is the Council of Ministers, made of ministers of foreign affairs of the African Union. So every year the court is reporting, and this is in the charter, in the protocol actually. The court has to report any cases of non-implementation of its judgment. And you can find this in all of its reports. For example, in the report of last year, the court has listed about half a dozen countries which have not respected the decisions of the court. Half of those countries are the countries which have withdrew their declaration. But also, for example, Kenya, which has been condemned by the African court to pay reparation in the case brought by the African Commission, the Ojek case, which were expelled from a forest where they used to live. So the court considered that the Ojek tribe is a people which has the right to development and the right to stay in the forest. And as a consequence, the court has condemned Kenya to pay reparation. But so far, those reparations were not paid. So the system exists. There's a system. So the Council of Ministers of the African Union is in charge of the implementation of the judgment of the court. Just like in in the European system, in the Council of Europe system. But it's not as sophisticated because in the framework of the Council of Europe, you have a full department within the Council of Europe itself, in the Secretariat, which is also monitoring. There's a Directorate of Human Rights. There's no such a thing in the African system. At the African Union, you just have the ministers.
Thank you so much, Fatsa, for this fascinating series of lectures. I assume probably because of the lack of time, you were not in a position to focus much on the African court on which you sat as a judge, as a vice president. One thing I find fascinating, I have always dreamed to join an institution with no history. You know, basically then you are present at the creation. It was your case, right? When you joined the court, it was an institution with no history. And I was wondering whether you can tell us something about that personal experience. You know, basically you shaped, together with your colleagues, an institution which basically didn't have any past.
I will give you one personal experience about that. When the court was established, it was established in 2016. We were sworn in 2016, the 1st July 2016 in Banjul, in the Sheraton Hotel in Banjul. And just after the swearing in before the head of states, I remember it was a very long ceremony, very long. So I was sitting, at one stage, Muammar Gaddafi came and he said just in front of me. And we were starving actually because we were sitting there for 6 hours with no food, no water. And Muammar Gaddafi ordered some coffee for him and his delegation, who were sitting nearby with his bodyguards, women bodyguards, and he offered us coffee. So we had a cup of coffee. So we're sitting, waiting for the sworn-in. We sworn in, and just after the sworn-in, we had a meeting, the first meeting of the African Court. And in anticipation of this meeting, I brought with me from the ICJ, because at that time I was the secretary of the court, I brought with me a robe. Actually, it was the robe of Judge Higgins. I asked Judge Higgins to lend me her robe, and she accepted. So she lent me her robe, and I came to the meeting. I put the robe on the wall, and I said, I have an example. So we have to do lots of things, the rules, etc. And we have also to design a robe. And then the problem started. They didn't want to have this robe. I said, no, this is just an example. I know 2 places who can design those. One in Paris, in front of the Palais de Justice, and one in The Hague. And they say, no, we want something in Africa. I said, no problem. Find a place in Africa, in South Africa, we're gonna. And they say, but we don't like this. I said, no, it's an example. Let's just build on this. Maybe we can put some colors, we can change. This is the model. At the end, we have to constitute a commission on the robe. A commission on the robe. So we created a commission on the robe, and it took 2 years. It took 2 years to design the robe. And at the end, we came back to the model that I proposed with some colors: yellow, green, and white. And then the judges were not happy because they said it's not well done, because the tailor was not so good. And then some women came, women judges came, and they didn't like the jabot. So we have to come back to South Africa to make new ones. So this is one of the examples. There are many other examples. You know, I was also chairing the Committee on the Rules, which was very interesting. I was chairing the commission. I made also an organigram because I was the only person, the only judge who had an international experience within a court. So I created a structure for the staff. And, but this is confidential, so maybe it shouldn't be recorded. So I provided for some legal officers. I think I provided for 4 legal officers because we didn't have much budget at that time. And 1 security officer, like at the ICJ. So I created a P4 level legal officer and 2 or 3 P2 and P3, altogether for half a dozen legal officers. And I was attacked by my colleagues. They say, how come? Only 1 security officer, and why 5 legal officers? We don't need 5 legal officers, we're gonna draft. I say, no. And at the end, we changed the whole structure. we changed the whole structure, hiring as many security officers as legal officers. So this was another example of my experience. The third one is about the importance of the registrar. The registrar. So I explained to my colleagues that it was important to have a registrar who was a good lawyer, but who can speak languages, and who is also a good diplomat, because he's the one who is dealing with parties. So they say, no, the registrar is not important. It's just, in any case, he's not going to attend the meetings. So come on. At the ICJ, the registrar sits on the left-hand side of the president, and the right-hand side is the vice president. The registrar has to be there. No. The registrar is not going to draft. We're going to draft. We're going to do everything. At the end, in the beginning, so they refuse that the registrar comes, and then they realize that if the registrar and the legal officers are not working, who is going to work? So then we entrusted the registrar and the legal officers with the drafting of some documents. And of course, we allowed the registrar to come. But the registrar is still up to date, I think up to date, is still not sitting together with the judges. He's sitting behind the judges in the corner. So I would have many other experiences to share with you, but it was a passionate experience because we have to do everything, even buying computers, iPhones, and the recruitment itself was very interesting as well. So this was my best years actually with the African Court. And when the court was finally installed and the routine was there, I wouldn't say that I was bored, but fortunately, I couldn't do more than 2 mandates, so I had to leave, and with no regrets. Nico?
There are no more questions? Let me just... Yes.
Sorry, can I about question about criminal jurisdiction? Because you mentioned the African Court will treat criminal cases, including the illegal exploitation of natural resources. I think it's great progress to ensure the permanent sovereignty of natural resources. But sometimes this kind of exploitation committed by the private actors, like companies. So my question is that this criminal jurisdiction apply to the private sector or not?
Yes, the reply is yes. It applies to the private sector. Multinational corporations, yes. And then you have to define who is in charge. It's the same with unconstitutional change of government. Who is in charge? Only the person who is running the coup or other people as well. So there are lots of questions actually raised by this list. It's not the only one. There are many questions. Because if you see money laundering, trafficking in persons is done by private enterprises of people. So those people can be indicted under the provisions of the Malabo Protocol.
Okay, thank you so much.
If I may, I will just finish with what the African Institute is doing in order to promote the rule of law in Africa. I'm so sorry. As I mentioned when I started this series of lecture, the African Institute has been established by Judge Abdulrahman Yusuf in order to strengthen the rule of law in Africa, because there cannot be economic development without investment and without stable rules, without independent jurisdiction, without well-trained judges, lawyers, and paralegal staff. So this is the reason why Judge Yusuf in 2012, together with me, created this African Institute based now in Arusha, Tanzania. So we have many, many programs. Last year we conducted about 25 activities, but those are the flagship program of the African Institute. On this coming Monday, we are organizing a follow-up conference on the rights of women. This time, we started last year with this conference with the support, the generous support of the Swiss government, the Federal Department of Foreign Affairs. And this year we made another conference as a follow-up, this time focused on violence against women and human rights defender. So we have also the Kilimanjaro Summer Academy, which has been designed along the lines of the Hague Academy of International Law. The first edition was held last year in July. We have also the Continental Shelf Summer Academy, designed to train civil servants, diplomats, judges of countries. This is with the support of the Faroe Island University. We have another program, the fourth African International Legal History Project, dwelling on the history of international law to see to what extent Africans were also producing rules of international law before the coming of the European powers. 5, empowerment of young African lawyers, scholars, in order to assist young scholars to draft articles in order to encourage the publication. As far as the publication are concerned, we have the African Yearbook of International Law, which exists now for the last 30 years, under the chairmanship of Abdulhawi Yusuf and myself. And then 2 years ago, we decided to pass the baton to the new generation. And last but not least, we have in the pipeline the master degree on the public law of Africa, which we were trying to organize together with the University of Addis Ababa. So it's with Dar es Salaam University. And it's been a long-awaited project, and we are working very hard on that. Thank you very much for your attention. If there's no other question, I will leave the floor to my friend Nico.
Thank you so much, Fatsa. Yeah, I'm not going to speak for long because I'm not on substance here, but I wanted to thank you really for giving the series of lectures on a topic, Africa and international law, which unfortunately still is kind of too often ignored and marginalized. And I think it was really important to have the possibility. 4 lectures are probably not enough, right? But I think you've seen in various briefs that one could have done much, much more about it. And of course, also the projects of the African Institute show kind of how much interesting material research is being done on international law in Africa, how many interesting developments take place that one could all discuss much further. And I have to say, I would really be interested in hearing more about judicial borrowing beyond the ropes. I find that it's one of the best examples of judicial borrowing that I've ever encountered. Yeah, just to say thank you so much. There was, in a sense, a start. I think it was really, fantastic that we could have that here, and that especially you were able kind of to give those lectures, because I think there are very few people placed as well as you are to tell us, our students and all of us, about international law developments, in a sense, kind of with a bigger picture view than you are. And so, thank you so much.
Thank you. And thank you very much for your sustainable attendance and your questions and comments. And I stay at your disposal at the library, because I still have lots of work to do at the library. So whenever we can meet at the library, it will be with pleasure that I will meet with you and chat on some issues, or simply to have a cup of coffee.
Thank you.